Welcome back to the show, everybody. We got a great one lined up for you this morning. How about Ripple versus SEC? And how about the idea that we may be looking at a settlement in play? We're going to hear from Jeremy Hogan, John Deaton, and James K. Filan. Let's go ahead and roll that beautiful intro.
This is Digital Perspectives with Brad Kimes. Subscribe for new content notifications. Now, here's Brad Kimes. Come on in.
Welcome back to the show, everybody. XRP is 72 cents this morning, was high as 76 cents. The bottom range at 69.94. Head on a swivel. This is crypto. You never know. We're going to be talking about Jeremy Hogan's latest video, which suggests that possibly, Ripple and the SEC may be in the middle of a settlement. Now, that would be incredible. We're also going to hear from John Deaton on the matter, and we're also going to hear the thoughts of James K. Filan in a full balanced delivery of what we're looking at here, or maybe not, right? So let's go ahead and know that this is 72 cents this morning for XRP, 0.7239. The numbers are brought to you by I Trust Capital this morning. Already have a crypto IRA? It's time you leave that zombie company. They offer lower fees, more assets, 24/7 trading, and institutional security and custody through Coinbase, baby. Reach out to them. They're amazing. This is the tag. I said hashtag come on in, hashtag settlement, or should I say asterisk? You're going to find out in just a second. If you haven't seen the video, you should watch the entire video. Not only is Jeremy Hogan a brilliant lawyer and gracious enough to share his insights and perspectives with all of us, but he also is a brilliantly funny person. So make sure you check out that video. We start here this morning at 2 minutes where he makes the case. Let's take a look at what he's got and how he lays it out.
Ordered. Looking at page 51 of the transcript, the judge said, quote, "I'm going to grant in large part the defendant's motion. I think that the discovery related to Bitcoin and Ether is relevant. I think it is relevant to the court's eventual analysis with respect to the Howey factors. I also think it is relevant to the fair notice defense that Ripple is raising." Later, after that hearing, the issue of those documents came up in a June 14th letter to the judge, where it seemed the SEC, quote, "promised to substantially complete its production of the internal documents before July 2nd. And if you were listening to the court hearing on July 15th, you might recall the Ripple lawyer at the very end of the hearing complained to the judge that the SEC had not produced one single internal document as ordered. And the judge said something to the effect that if that was the case, they should file a brief with her the next week and she would rule on it. Now, that would have been last week what the judge was requesting, and guess what? Nothing was filed. Nothing. Now, was this issue suddenly resolved out of thin air? The SEC is raising a privilege defense to producing these documents, and so they had to give Ripple what's called a privilege log, and it's basically a list of all the documents that the SEC is saying they don't have to give Ripple. And I, for one, refuse to believe that Ripple isn't going to think that at least one of those documents should be given to them. But yet, we haven't seen the motion to compel the production that the judge requested. And it's not because there's a lot of time left to do it. Believe it or not, there's only 1 month left of fact discovery. So suddenly this humongous area of contention disappears in a puff of smoke?
There you have the first part of this laid out. Now let's go ahead and move to the next spot here, which is at right here, 342. And I'm going to let this play. He's going to continue to make the case of all the things that really aren't adding up to suggest that maybe, just maybe, the SEC and Ripple have a settlement in play. Keep listening.
Of former Director Hinman, the SEC strongly opposed the deposition in its entirety and requested the judge quash the deposition, which is a cool way of saying stop it. Looking right at the first sentence, quote, "Plaintiff Securities and Exchange Commission, SEC, respectfully requests a conference with the court to seek an order quashing the deposition subpoena directed to William H. Hinman," close quote. So the matter was briefed, and the hearing was held on the deposition, and something very strange jumped out at me during that hearing on July 15. But there's something that jumped out at me that you might have missed, and I had to go get my notebook so I could remember. Remember, nothing gets by me except if I don't make a note of it. So when it became obvious that the judge was going to allow the deposition to move forward, she asked the parties whether it was moving forward on Monday because it had been scheduled for the 19th already, and Ripple said, yes, it's moving forward. And the attorney for the SEC said she wasn't sure that we would need time to evaluate that, is what I wrote down. Now, this was a scheduled deposition. The judge said that she was going to allow it to go forward, but the SEC will evaluate that? Very curious. And that was it. It was kind of a tell during the hearing that the SEC was desperate to not have the Hinman deposition take place. And also, recall how far apart the parties were on what the deliberative privilege protected Hinman from questioning. The SEC basically argued that everything Hinman said outside of public speeches was privileged, and Ripple argued that almost nothing was privileged. The parties were basically a Grand Canyon apart. So imagine my surprise when just 4 days later I see this letter, and in paragraph 2, quote, "We have reached an understanding pursuant to which the defendants may examine Mr. Hinman without triggering a privilege objection from the SEC," close quote. Really? The Grand Canyon was crossed just like that? What is this, Evel Knievel jump? And what happened a couple days before that miraculous agreement? Something I've never seen before in litigation. Two commissioners of the SEC come out arguing, essentially, that Ripple's fair notice defense was valid, that market participants do not have fair notice in the crypto space. So, now it is July 29 as we film this, and the deposition of Mr. Hinman was supposed to have taken place on July 26th, 3 days ago. Having watched this litigation from beginning, and with the stakes as high as they are, I refuse to believe that former Director Hinman, with all that is on the line, marched into the conference room on the 26th and answered all the questions posed to him by Ripple's lawyers. I just refuse to believe that. I've had small claims cases where I've sued for $10,000, where I fought tooth and nail over one single question that the deponent didn't answer under a privilege objection. Now, maybe the $20 million Ripple legal team, with more lawyers than most soccer teams have players, needs more than just 2 days to brief the issue when it is under a discovery cutoff of around only a month? Possible, but not likely for me. But all of these recent things are and very interesting, but we can't really draw any conclusions from them other than that they are really just not very likely to happen in a case like this.
And remember that, right? He is telling you, he does say there's room for these things don't add up, but we can't absolutely know for sure what's really going on. Let's keep listening now.
But you came here for my rampant speculation and conclusions, and as always, I aim to please. So I'm going to speculate two things for your viewing pleasure. First, I don't think the deposition of Director Hinman took place this last Monday. If it had, where is the transcript to be filed under seal for an in-camera review by the judge? Where is the motion to compel Hinman to answer certain questions? Is it possible that the SEC and Ripple attorneys suddenly became little lawyer angels and agreed on everything last week so that they wouldn't have to burden the judge with their bickering? No, trust me, that lawyer doesn't really exist. Which leads me to conclude that the deposition never took place. So that's my first speculative conclusion, which leads me to my second and last speculative conclusion, which is one that might have escaped mere mortals, but I was on another plane of existence when I saw this and what it meant. Peyote. So stay with me here for the last point. Recall that shortly, very shortly after the commissioner's statements came out, basically supporting Ripple, that the individual defendants filed the statement with the court, along with an explanatory letter, and that happened on July 19. Then Ripple turned around the very next day on July 20 and filed basically the same thing. And why did it file the statement right away? Look at paragraph 2, quote, "To ensure that the record on the motion to strike is complete, Ripple requests that the court consider the two commissioners' statement to the court in support of Ripple's fair notice defense," close quote. Now at that point, the SEC motion to strike Ripple's fair notice defense, which is extremely important, was fully briefed. The SEC filed the motion, Ripple replied, and the SEC replied to the reply. So the motion is fully briefed at that point, and what that means in federal court is that after the issue is fully briefed, a judge can rule on it, and Judge Torres can rule on that motion at any time without further notice, without even oral argument. So they got it in right away. Then the next day, on the 21st, we saw the SEC respond to both the individual defendants and Ripple in one response letter. And then on the 23rd, the individual defendants filed a reply to the SEC. So now the individual defendants had fully briefed the issue and their record was complete. And on Twitter, on July 23rd, I wrote, quote, expect to see the Ripple reply shortly. And I wrote that on July 23rd, and then it was July 24th, and then it was the 25th, the 26th, and today it is July 29 and no reply. Ripple never replied to the SEC's brief. Again, you have some of the best security lawyers in the country working for Ripple, and this is a reply that is time sensitive, and it still hasn't been filed. Ripple has not replied and has left unaddressed the issues raised in the SEC's reply of July 21st. Now, wow, did Ripple blow it? Do Ripple's 23 lawyers need more than 9 days to draft a 3-page reply brief? Or, wait for it. Or is it possible, or yes, even likely, that Ripple didn't bother to file a response to the SEC because it didn't need to? And why didn't Ripple need to? Well, here we go. Ripple didn't need to file a reply because there were serious discussions going on regarding
a settlement. And that's where we got to cut it. And I'm not sure if the stuff that he used was a copyright strike or not. So I don't want to go any further with it. But I mean, Jeremy, brilliantly funny, brilliant insights all the way around. We don't know what the answer is, but these things are incredible points that he is making that we should consider. And now let's switch to John Deaton, who we know hasn't heard back from his filing to be heard, the motion to intervene either, to add to the points that Jeremy Hogan just made. But let's pick it up here. He says, and he watched Hogan's video and definitely agrees that a few things don't add up considering how contentious the last hearing was. In fact, after the parties informed the court that they had reached an agreement regarding the Hinman deposition going forward, John Deaton tweeted out a prediction that Judge Netburn would ultimately have to rule on the privilege issue related to both the Bitcoin and Ether discovery and the Hinman deposition. Don't forget, the Ripple attorney informed the judge that despite her 2 orders, the SEC had not produced one single document. Ripple's attorney stated that the SEC was taking the position that every single document was protected by privilege. Furthermore, the SEC attorney stated she would instruct Hinman not to answer any questions regarding his speech, I remember that, and communications with other SEC staff. The SEC attorney argued on the record that any such documents or communications were part of the deliberative process. But Hinman's speech was allegedly his personal opinion, never adopted as official SEC policy or guidance. This is a great point John Deaton makes here. If it's his personal opinion, then how could it be a part of the deliberative process of the SEC? What a great question. The SEC didn't deliberate or decide anything if it's a personal opinion. Come on in, John Deaton. Yeah, hence I predicted that Judge Netburn would have to decide what's protected by privilege and what's not protected. Like Jeremy, it is difficult for me to believe every single document and communication is privileged. Usually, the judge would review the documents herself and decide. And then he says here, bottom line, if we don't see Ripple file a motion to compel or a request a ruling on the issue of privilege very soon, then I doubt Hinman's deposition went forward and agree with what my friend Jeremy was trying to say, whatever he was being hushed up about in that video, which is a settlement, potential settlement. Okay. Full balance, full disclosure, right? Fair and balanced delivery here. James K. Filan, who has been supplying us with incredible up-to-date information, has a different perspective on what may or may not be going on. Let's hear his thoughts here. And shout out to James K. Filan, John Filan, John Deaton, and Jeremy Hogan for putting all of this out on the table for us to understand and to discuss. Here we see everything I say here is his speculation, and everyone is speculating in this, but based on his experience, he says he has a different take on what is happening in the case. He says, I don't think that anyone should expect a settlement anytime soon. The government is not giving up, and based on everything he has read, the Ripple will not give in. He said, I do think that Hinman deposition went forward. I don't think Ripple would forfeit that opportunity. Ripple said Hinman has unique firsthand knowledge about the SEC's communications with third parties and about the agency's adoption or approval of his well-publicized speech in 2018 about the regulatory treatment of cryptocurrencies. If they can find out specifically who he spoke with and what was said, information that Hinman can himself provide, Ripple can learn information about what the SEC said to the market participants that is crucial to Howey. The aiding and abetting charge and fair notice defense, my take is that Ripple got names of who Hinman and others talked to and what was said, and now Ripple is out there interviewing those people. He says he also understands that people are mad about the SEC's actions and inactions after all this time. But in his opinion, this case really isn't about punishing the SEC or anyone else. When a party focuses on hurting the other side, they lose focus on winning for themselves. This is a case about winning and making the whole crypto space succeed. If the SEC or anyone else gets hurt in the process, they brought it on themselves. But that's not the goal. The goal is to clean this mess up and move forward. So I don't think a settlement is coming anytime soon. This is a war. I think we should settle in for the long haul. I have to thank all of these gentlemen for sharing their points of view and insight and their speculation, because none of this from them or myself is financial advice in any single way. So, all right, so look at this right here, or collectively. None of it is financial advice. So Kenwood Capital reminds us, said, hey, take it, everything that we just listened to and we just heard, and remember this little fun fact. The Sunshine Act notice about closed meetings that the Securities Exchange Commission has, well, they delay those a lot of time and postpone those, and we've seen that happen. However, there was a meeting that was ironically enough scheduled yesterday, Thursday, July 29th, 2021. I don't yet know if that meeting was postponed like many others that we've seen. But if it did go down, this is what it was about. The subject matter of the closed meeting will consist of the following topics: institution and settlement of injunctive actions, institution and settlement of administrative proceedings, resolution of litigation claims, and other matters relating to examinations and enforcement proceedings. Oddly enough, all of this seems to be right here at this intersection of yesterday and potentially this meeting if it didn't get postponed like the many other ones we have seen. So we have to keep that in mind too. But all of this, I think, is the most current and clearest look at where we are today and where we may or may not be. I just wanted to do a definitive video that brought everyone's opinions and speculation into this so we could all bring it in and process it in how we need to, and then try to look forward and see where we may end up. All right, before I get out of here, I tell you all the time, Robinhood IPO'd yesterday. I showed you the picture. Robinhood was offered on here on link 2 at its very inception at $11. If you had bought it on link 2 as private equity, you would have rode that ride to a $38 IPO yesterday. Yeah. Oh, yeah. That's what I'm talking about. Ladies and gentlemen, keep an eye out. Uphold's going to be replenishing on this board. None of this stuff lasts long. Innovium has already run out. I mean, Kraken's on here, but it won't be for long. Ladies and gentlemen, if you're an accredited investor and you don't know if you are, you really wouldn't believe it. You and your wife may be accredited together. Make sure you check it out. Go through the process, find out for yourself. Click all the links in the description and comment box. They are trusted products and links that I have already tested, and I use these products and services each and every day. So make sure you check those out as well. And I will catch all of you on the next one.